Good morning, sir. Can you see and hear me?
Yes, I can, thank you.
Apologies for the delayed start, down to me entirely, and a problem with my computer.
Well, I'm not entirely surprised that occasionally there can be problems with computers.
Yes, the problem was identified very quickly and remedied.
Thank you.
Sir, can we turn to charging decisions? And we were in your report, Mr. Atkinson, good morning, at page 55.
Yes.
So that's EXPG 54602. And at page 55, please. Thank you. From this paragraph 118 onwards, right up to paragraph 132 of your report, you consider the charging decision process and the charging decision process at the post office as reflected in policy documents.
Yes.
And you essentially address two questions: would this be right? And I'm drawing this from the document rather than you expressly stating it. Was the structure of the charging decision-making process sufficiently well defined in the policy so as to ensure consistency, rigour and fairness according to the law? Would that be one question?
Absolutely.
And secondly, did the structure provide for sufficient oversight at a senior and/or independent level?
Yes.
Thank you. And before we get to the answers to those questions, can I briefly address, if I may, the comparators and the sources of material that you identify? Firstly, can we go to paragraph 128 of your report? Which is on page 59. You address, if we just get the heading there so we can see what we're looking at, just scroll up a tiny bit, please. Thank you. The director's guidance on charging. And between this paragraph and 131, you address and cite extensively from the directors, that's the Director of Public Prosecutions, guidance on charging. Can you help us? When was the director's guidance on charging first issued?
I haven't been able to identify a first version, but the requirement that the director should introduce such guidance was brought into the Police and Criminal Evidence Act by the Criminal Justice Act of 2003, and so it would have been shortly after that.
I've been able to track down a second edition dated 2005, so that would sound about right.
Yes.
So after 2003.
Yes.
But certainly before 2005, because we were on a second edition.
Yes, and just to explain, the Police and Criminal Evidence Act, as originally enacted, in the main put the decision as to charge on the part of a custody officer at a police station. There was then an increasing move away from the decision being taken by the police and more taken by the CPS. And that's what the change in the Criminal Justice Act 2003 was designed to achieve.
Yes, and there was, I think, a Section 37A introduced into PACE,
yes,
which introduced the requirement to issue guidance.
Yes.
And so the guidance has been in existence for some, but not all, of the relevant period that we're looking at.
Yes.
And can you tell us, in summary, what is the director's guidance on charging?
What it seeks to do is to make clear the process by which the police should carry out, once they've carried out an investigation, then seek advice either during the course of that investigation or certainly before a charging decision is reached from the Crown Prosecution Service, the duty on the prosecutor to assess that investigation and then to apply the Code for Crown Prosecutors to it. So it sets out the process and underlines the independence of the decision to charge from the decisions made during the course of an investigation.
Thank you. Would you agree with the suggestion that it's a recognition that even the Code for Crown Prosecutors does not provide every assistance to those who must make decisions about charging a person with a criminal offence, and that more assistance was needed?
Yes.
In any event, can we take what you say about the Director's guidance from your paragraph 132, which is on page 62, at the foot of the page. You tell us, in summary, therefore, in cases involving the police and CPS as the investigator and prosecutor, the structure of responsibility is clear. That is, that in all but the least complex or serious of cases, the decision to charge is a decision independent of the investigator and by reference to a clearly defined two-stage test taken by reference to clearly defined material. The structure also makes clear where the final decision lies.
Yes.
You'll appreciate that I'm skipping a lot of material. I've skipped the material that you have helpfully included in your report about the development of the
yes.
move away from a charge within a police station by a custody sergeant, the increasing role of the Crown Prosecution Service in either making decisions on charge, advising on charge, and the division of responsibility as it now is.
Yes.
So that's the Director's guidance. Next, in paragraphs 133, so over the page, please, to 154, you address the Code for Crown Prosecutors. And again, the material is quite dense here. May I summarise it and see whether you agree with my summary of what you said? Firstly, the Code has a statutory basis, see yes. Section 10 of the POA 1985.
Yes.
Secondly, the Code does not apply directly by reason of Section 10 to those undertaking prosecutions outside of the CPS.
No, that's right.
But thirdly, a range of organisations and agencies have decided to bind themselves in their decision-making by doing so by reference to the Code, including the DWP, the Environment Agency, and the Health and Safety Executive.
Yes.
And fourthly, the full Code test, which is what's relevant for our present purposes, involves two stages. Firstly, an evidential stage, and then secondly, consideration of whether the prosecution is in the public interest.
Yes.
And ordinarily, such tests are to be approached in that order. Evidential stage first, public interest second.
Yes.
Thank you. Can we turn then to page 68 and paragraph 145? And I'm going to slow down and deal with this in slightly more detail. You tell us here that the evidential stage, the prosecutor must be satisfied that there is sufficient evidence to provide a realistic prospect of conviction. Consideration must be given to what the defence case may be and how it is likely to affect the prospects of conviction. A case which does not pass the evidential stage must not proceed, no matter how serious or sensitive it may be. There is a realistic prospect of conviction if, quote, an objective, impartial and reasonable jury or bench of magistrates or judge hearing a case alone, properly directed and acting in accordance with the law, is more likely than not to convict the defendant of the charge alleged. And then you set out the questions that a prosecutor should consider in answering this question. And you say that they are identified as. And is that identified in the 2018 8th edition of the Code?
Yes, and equally in the earlier editions that I've been able to identify.
We're going to look at those just very briefly in a moment, because I think the number and nature of pointers
Yes.
changed over time. I'm not sure relevantly, but I just want to look back at the earlier iterations. In any event, in this edition of the code, the questions identified: can evidence be used in court? Is the evidence unreliable? Is the evidence credible? Is there any other material that might affect sufficiency of evidence? Can we look at the 2004 edition, please? And go to RLIT 40171. And so this is the 2004 edition of the code as reprinted in an appendix to Blackstone's.
Yes.
And if we look, please, at the second page, under the heading The Evidential Stage, and look at paragraph 5.4, the guidance back in 2004 was, when deciding whether there is enough evidence to prosecute, Crown prosecutors must consider whether the evidence can be used and is reliable.
Yes.
There will be many cases in which the evidence does not give any cause for concern, but there will also be cases in which the evidence may not be as strong as it first appears. Crown prosecutors must ask themselves the following questions. Can the evidence be used in court? I could do that, skip over that. And then under the heading, is the evidence reliable? Is there evidence which might support or detract from the reliability of a confession? Reading on, what explanation has the defendant given? Is a court likely to find it credible in the light of the evidence as a whole? Does it support an innocent explanation? A question about identity. And then E, is the witness's background likely to weaken the prosecution's case? For example, does the witness have any motive that may affect his or her attitude to the case or a relevant previous conviction? And are there any concerns over the accuracy or credibility of a witness? Are these concerns based on evidence or simply information with nothing to support it? Is there further evidence which the police should be asked to seek out which may support or detract from the account of the witness? Crown prosecutors should not ignore evidence because they're not sure it can be used or is reliable, but they should look closely at it when deciding if there's a realistic prospect of conviction. And then if we can turn, please, to RLIT 40170. Thank you. And turn to the third page, please. This is the 2010 edition of the code. And paragraph 4.7 is similarly worded as to, by way of introduction, as the previous edition of the code. And then under the cross-heading, is the evidence reliable, you'll see a slightly expanded section. What explanation has the suspect given? Is a court likely to find it credible in the light of the evidence as a whole? Does the evidence support an innocent explanation? Is there evidence which might support or detract from the reliability of a confession? Is its reliability affected by factors such as the suspect's level of understanding? Then the question about identity. G, are there concerns over the accuracy, reliability, or credibility of the evidence of any witness? H, is there further evidence which the police or other investigators should reasonably ask to find which may support or undermine the account of the witness? I, does any witness have any motive that may affect his or her attitude to the case? J, does any witness have any relevant previous conviction, etc.? Is there any further evidence that could be obtained that would support the integrity of evidence already obtained? And then scroll down, please. And then at 4.9, exactly the same guidance as before. So in both of these editions of the code, and in the present 2018 edition of the code, which you cited, prosecutors were asked to ask themselves a range of questions
Yes.
that went to the central issue of reliability. Would that be fair?
Yes.
Can we turn back to your report, please, and look at page 68. Uh, 68, and it's paragraph 146 at the foot of the page. So picking up where we left off, 146, you tell us that it follows that the reliability of the evidence is identified as being a central consideration to whether there's a realistic prospect of a conviction. Is that a theme that has run through every iteration of the Code for Crown Prosecutors?
Yes, certainly all that I've seen.
And so what's that telling a prosecutor to do?
Clearly, it will tell them different things depending on the nature of the case that they're dealing with. If it's a case with eyewitnesses, then it's all about the reliability of the eyewitness accounts and whether there is material that supports or undermines that. But at a fundamental level, it is telling the prosecutor that they need to consider not just what the evidence in front of them says, but whether it is reliable in doing so, and whether there is either material available or material that needs to be obtained, that will affect or may affect its reliability, because they need to be satisfied that that which goes forward if they charge is a reliable case.
And so one can't say simply because the words on the page or the figures on a page are in front of me, I need only look at those and decide whether there's a realistic prospect of a conviction.
No, that's right.
One needs to apply a probing mind to look at the issue of reliability.
Yes, so if you have a case where a witness says, I saw the defendant do it, you don't just say, oh, well, that's fine. You have to consider whether that person is reliable, whether there's material that might undermine their credibility or reliability in assessing whether there's a realistic prospect of a conviction based on what they say. And in the same way, if you have a computer spreadsheet that says effectively that the defendant did it, you have to be satisfied that that is a reliable basis for asserting that.
Thank you. Can we move on to the public interest stage,
yes,
please? And that's over the page to page 69 and paragraph 148 of your report. You tell us that if the evidential stage is satisfied, the prosecutor must consider whether the prosecution is in the public interest. As the Code observes at paragraph 4.10, quote, it has never been the rule that a prosecution will automatically take place once the evidential stage is met. A prosecution will usually take place unless the prosecutor is satisfied that there are public interest factors tending against prosecution which outweigh those tending in favour. In some cases, the prosecutor may be satisfied that the public interest can properly be served by offering the offender the opportunity to have the matter dealt with by an out-of-court disposal rather than bringing a prosecution. And then at paragraph 149, you tell us that the prosecutor is required to consider the factors identified at paragraph 4.14 being 1, the seriousness of the offence, 2, the level of culpability of the suspect, and the Code lists relevant factors including the suspect's level of involvement, the extent to which the offending was premeditated or planned, the extent to which the suspect had benefited from criminal conduct, whether the suspect has previous criminal convictions and or out-of-court disposals, and any offending whilst on bail or whilst subject to a court order, whether the offending was or is likely to be continued, repeated or escalated, and the suspect's age and maturity. Thirdly, the circumstances of and the harm caused to the victim. Fourthly, whether the suspect was under the age of 18 at the time of the offence. Fifthly, the impact on the community. Sixthly, whether the prosecution is a proportionate response. And lastly, whether sources of information require protecting. And so that is a developed list of factors that is not exhaustive.
No.
Is that right?
That's absolutely right.
But they're pointers.
Yes. And in each iteration of the code that I've seen, there has been a list. It's never been just a question of consider the public interest, full stop. It's always been a whole series of factors.
Once the full code has been applied, the full code test has been applied, and it's been decided to prosecute, is that the end of the matter, or is there yet a further question that arises, namely what charges should in fact be preferred, or what information laid?
It's not the end of the process in two ways. Firstly, that once it has been identified that there is a realistic prospect of conviction on the basis of the evidence and in the public interest to do so, you then have to determine what charges should be laid. But you then also have the continuing obligation, which, as I've read it, has been consistent throughout the iterations of the code, to keep that process under review, both as to whether you've got the right charges and as to whether it remains in the public interest and it remains a realistic prospect of a conviction.
Can we look, please, at page 71, paragraph 154 of your report? At the foot of the page, which addresses one of those two ways in which the satisfaction of the two elements of the test is not the end of the matter. And you tell us that the code also addresses the determination of what offences to charge, where the full code test has been applied and prosecution has been determined upon. At paragraph 6.1, it stated that the charges should, quote, reflect the seriousness and extent of the offending, give the court adequate powers to sentence and impose appropriate post-conviction orders, allow a confiscation order to be made in appropriate cases where a defendant has benefited from criminal conduct, and enable the case to be presented in a clear way. You add, it follows from this analysis that the interests of justice do not always require the charging of the most serious potential charge, and you cross-refer us to paragraph 6.2 of the code, and that the prosecutor should never seek to pressure a defendant into pleading guilty through the charges chosen, and should, as you said, keep the charge under review, paragraph 6.3 and 6.5 respectively. The idea that the prosecutor should not seek to pressure a defendant into pleading guilty through the charges chosen, can you give us an example, a practical example of that? What does that mean in practice?
So the charges should not be chosen so that a defendant feels they have to plead to something to avoid the risk of being convicted of something more. So just to take an example, one should not charge false accounting as well as theft to make a defendant feel they have to plead to false accounting because they don't want to be convicted of theft.
Thank you. Can we turn then to the adoption of the code by the Post Office in its policies? And can we turn to page 72 of your report, please, and paragraph 155? You tell us that the Post Office has at least purported to apply the code for Crown prosecutors, and that's demonstrated by the following. And you list 5 policy documents that in different ways, I think, represent the Post Office saying that it will either apply or have regard to the code for Crown prosecutors. Is that right?
Yes, either expressly, so for example that in paragraph A refers to the code, that in paragraph B doesn't refer to the code but does refer in general terms to the test from the code, and so I took it as being a reference to the code.
Thank you. Would you agree that as a private prosecutor, the Post Office was not obliged to apply the code as a matter of law?
Absolutely.
But as you've set out, the Post Office did.
Absolutely.
And so does the fact that the Post Office was not obliged to apply the code as a matter of law have any continuing relevance in the light of their decision to do so?
No, I don't think so. I think that it was recognised in those cases where it was said that a private prosecutor was not required to apply the code, that there was nevertheless a requirement that a defendant understand the basis for the decision being made to prosecute them. And increasingly it was recognised that the code was a clear statement of that which, however you worded it, would need to be considered by a prosecutor. But it seems to me once the Post Office had determined that they would apply the code, that is the standard against which you can judge their decisions, because it's the one that they'd adopted.
And so the fact they weren't obliged to apply it as a matter of law hasn't got any continuing relevance in examining whether the Post Office did in fact do what their policy said they would do?
No.
Can we go over the page, please, to page 73? I want to look at paragraphs 156 and 157. And as I read this, you're identifying some outlier policies, essentially. Would that be fair?
Yes.
Which are not consistent with the policies that you had identified, the 5 of them, in paragraph 155.
Yes.
And if we just read those, you say that the crime and investigations policy of September 2008, October 2009, and April 2011 states, quote, where a business leader, manager, or employee is the subject of a criminal investigation and grounds are established to suspect them of having committed a criminal offence, breached Royal Mail Group's Code of Business Standards, or subverted business systems, controls, or policies, they may enter one or both of the following processes: the relevant national criminal justice system and the business unit code of conduct. You say that the policy goes on to say, once committed to the relevant criminal justice system, it's the accountability of the Royal Mail, its investigators, criminal lawyers and prosecuting agents to ensure that the case is presented impartially, but with all possible evidential support and preparation. It's the function of the relevant court to decide upon guilt. But you make the point that the policy seems to identify no more than mere suspicion as a precursor for a case entering the criminal justice system and doesn't include any guidance for prosecutorial decisions that are to be found in the Code for Crown Prosecutors.
Yes, so I found this difficult to reconcile with the policies that we've just looked at, so that in 2007, the end of 2007, the criminal investigation and prosecution policy had made express reference to the Code for Crown Prosecutors as the test. And then less than a year later, this crime and investigations policy, rather than referring to the code and a determination of a sufficiency of evidence for there to be a realistic prospect of conviction, there was a reference to a suspicion of someone having committed a criminal offence being a reason to put them into the criminal justice system. I couldn't see readily how those two things could be reconciled.
And then paragraph 157, again, something of an outlier. A criminal enforcement and prosecution policy dated November 2012, addressing relevant factors to the application of the code, simply says on the evidential side, evidence of guilt sufficient to give a realistic prospect of success in criminal proceedings without any development of it. Is that
Yes.
the point?
Yes.
And then in relation to the public interest test, a list of factors to be taken into account which is summarised as the seriousness and effect of the offence, the deterrent effect of a prosecution on the offender, and others, and any mitigating factors. And what was the issue or the problem with that?
Again, that which is there is not in any way irrelevant from the assessment of the public interest, but nor is it the totality of that which is relevant to the assessment of the public interest. And so again, it was a more defined list of public interest considerations than in fact I'd seen in some of the earlier policies, but it was still far from a comprehensive one.
Thank you. Can we go to page 75 of your report, please? Between paragraphs 161 and 163 on this page, you refer to a draft formulation of policy written by Andrew Wilson, essentially suggesting that there be a presumption in favour of prosecuting those committing dishonest acts involving acquisition of property or assets from the Post Office in the course of their duties.
Yes, and again, I was less than clear as to the status of this paper. It was, I highlighted it because it was December 1997, and so it predated the inquiry's period of concern, whereas almost all of the documents that I otherwise saw came from within that period. But it was a fuller exposition of what the prosecuting policy would be than some of those other documents.
In relation to what Mr. Wilson suggested, would you agree that an offence of dishonesty in breach of trust by an employee involving either theft or the dishonest acquisition of property at the expense of their employer would be treated as a serious offence by the criminal courts?
Yes, if made out, yes.
And that in those circumstances, if a CPS lawyer was to be presented with sufficient evidence to prove such an offence, the lawyer would be likely to conclude that the prosecution is in the public interest, subject to any case-specific or personal circumstances that apply to the particular individual.
If they were satisfied that its sufficiency included its reliability, yes.
And that therefore, for the Post Office, it wasn't unreasonable to adopt a position whereby if there was sufficient evidence to have a realistic prospect of conviction and there were no countervailing personal or case-specific circumstances, prosecution should ordinarily follow.
Ordinarily, yes.
And so what's wrong with what Wilson is suggesting?
My concern was that it was a very bald description of a policy that there would be a presumption if there was evidence of dishonesty by an employee, they would be prosecuted without the nuance that the Code for Crown Prosecutors, by way of example, brings that process in terms of the range of factors that need to be considered, both in deciding whether you have sufficient evidence to establish that dishonesty and whether, even if you have, it's in the public interest to prosecute.
So it might, would this be right, encourage almost a rubber stamping of decisions to prosecute without sort of a deep dive into the circumstances?
Yes. If this was the policy, then that is the risk that it would run, yes.
Thank you. Can I turn to charging practice, please, and the related issue of plea bargaining? We ask you to consider, in the context of the Post Office's charging practice, the decision of the Court of Appeal in Eden. And that was because, in the light of what appears to be the Post Office's charging practice, and because of the high number of cases in which that charging practice had been applied across the relevant period, it appeared to be a relevant consideration. You tell us about the facts of Eden on page 76, at paragraph 165. Thank you. And can you just summarise for us, if you can remember, what it was that had come before the court?
Yes. So the defendant was a sub-postmaster who, in relation to whom discrepancies had been identified between voucher records on the one hand and payments out on the other. And so they were charged with a series of what were described as twin counts of theft and false accounting. And the issue that led to it going to the Court of Appeal was that the prosecution stance, which the Post Office's stance in that case, was to invite the jury only to convict of one of those halves of the twin, the theft, if they also convicted of the other, the false accounting. And the jury instead convicted of the false accounting, not the theft, making clear, unusually, because usually a jury just gives a verdict without giving its reasons, that they considered that the false accounting was made out on the basis that the postmaster had got in a muddle and falsified things to cover the muddle rather than to steal money.
And in those circumstances, you tell us in paragraph 166, I'm not going to read out what Lord Justice Sachs, speaking for the Court of Appeal, said in relation to this part. Given the jury had made clear that there was no dishonesty, the convictions were quashed.
Yes.
Over the page to page 167, please. Lord Justice Sachs additionally went on to say, quote, "It seems to this court to be rather off," which is the language of the day, that two counts, theft and false accounting, should be put in parallel setting if it's the object of the prosecution to secure a conviction on the first only if the second is proved, or on the second only if the first is proved. There would seem in those circumstances but little point in putting two separate counts. It would be better in future that the prosecution should make up its mind as to whether or not it really wants a conviction on account of false accounting only if theft is proved. If so, reliance should be placed on one count only. On the other hand, there may be cases when it's wise to have a false account, where, for instance, a temporary gain could be the object of the dishonest act. No such object was put before the jury in the present case. If we turn to paragraph 168, you say although those observations were made in 1971, it doesn't appear that the practice of charging both theft or false accounting was altered for almost the whole of the inquiry's period of concern. And then you cite from a paper written by Chris Oyard, and that's the paper that we looked at on the screen yesterday, but a different part of it, 3.1. And it said that the Post Office typically prosecuted sub-postmasters for false accounting combined with theft and or fraud, and went on to say the choice of charge is largely dependent on whether we've obtained an admission of guilt or other compelling evidence that the defendant has taken money directly from us, or have only secured evidence that the defendant covered up losses by falsely recording the branch's financial position. Typically, defendants plead guilty to a charge of false accounting, with the charge of theft then being dropped. Carrying on, you tell us in paragraph 169 that in a later document, criminal offences points to prove document of December 2008, which had as its purpose helping investigators and interviewers to understand the elements of criminal offences, which was updated in August 2011 and again in June 2012, did not address the Eden considerations as to charges. And you tell us that whilst training materials were produced that address the elements of offences of dishonesty, those training notes did not also address charging decisions nor the Eden considerations.
That's right.
If we go forwards, please, to paragraph 170, you tell us the choice of charge was not addressed in the various prosecution policies that you had seen until 2013, nor were the implications of Eden addressed. It was in the November 2013 Post Office Prosecution England and Wales policy that Eden was addressed, where at paragraph 5.2 it said, where a suspect is charged with offences of theft and false accounting arising out of the basic same facts, those charges will always be alternative charges. This approach is not to be regarded as an invitation to plead guilty to any particular charges. You were asked in the context of Eden the lack of specific Post Office guidance relating to it, and you say that no doubt the observations in the paper just quoted to consider the practice of plea bargaining in that context. And so essentially it was only at the end of the relevant period in 2013, November 2013, that Eden was addressed at all in the documents you've seen.
Yes, and so whilst, as the court made clear in Eden, there will be cases where it's entirely appropriate to have a charge of false accounting as an alternative to a charge of theft to address a different potential scenario, it is a process that needs to be thought through, and for an understanding as to why the false accounting is there as an alternative to be thought through, rather than it for effectively to be treated as a package deal that you would always have both.
Which seemed to be the import of what Chris Oyard said.
Yes.
Thank you. And so it was only at the end of the period, in November 2013, on the documents that you've seen, which I think is 42 years after Eden was decided, that the issue raised in Eden was addressed.
In anything that I saw written down, yes.
What were the, or what could be the potential adverse effects of a failure by the Post Office to follow the guidance in Eden?
One potential risk is that if it is regarded that you would always have that package deal of charges there might be a lack of scrutiny of whether in fact you had evidence that established theft. And so if the basis for a charging decision at the end of an investigation was that there were shortfalls in the computer records, and therefore a charge of theft on the basis the money had been taken, and of false accounting if it hadn't, that you would just have the package there without actually looking to see whether the evidence did show any loss of money in fact, as opposed to on the records. And the other risk, as identified, is that a defendant may consider that because they had to acknowledge that there were accounting shortfalls as shown by the records, that they had at least to plead guilty to false accounting because there was the risk if they went to court that they would be convicted of stealing the money. Whereas in fact that charge of theft may in fact never have been made out on the evidence at all.
Because, for example, there was no evidence of an actual loss.
Yes. And or an actual gain to the postmaster.
Would you accept that there can be factual circumstances which make a conviction of both theft and false accounting appropriate?
Certainly Lord Justice Sachs in Eden had concerns about that, and I think I would side with him.
Can we turn to plea bargaining, please? In paragraph 171 to 177, which is on page 78. Thank you. You, right up to paragraph 177, you outline the position so far as the CPS is concerned in relation to the acceptance of pleas. And for reasons of time, I'm going to take that whole section as read.
Yes, I think it's right to say that the guidance is not just CPS specific in the sense that the proper approach to taking a plea to a lesser offence than that originally charged, or the alternative count on an indictment. The guidance in relation to that is given in decisions from the Court of Appeal. It's given in the guidance from the Atkinson Committee, which speaks beyond the CPS to other prosecutors as well.
And indeed the Attorney General's guideline.
Yes.
Which speak to other prosecutors other than the CPS.
Absolutely.
Would you agree that in considering whether to accept a plea to a lesser or different offence to the one charged, the CPS would ordinarily seek and consider, even if they weren't bound by them, the views of the victim?
Yes.
And would you agree that whilst the victim's views should not be considered determinative, they are a relevant consideration to bear in mind in reaching a decision on prosecution?
Yes.
And plea?
Yes.
Given that the Post Office acted as a private prosecutor and was both prosecutor and victim, would you agree that it was appropriate for the Post Office's business interests to therefore be a factor when deciding whether to accept a plea to a lesser offence?
Yes, but with the proviso that where you are both the prosecutor and the victim, the need for that process to be transparent and the criteria that you're applying to be readily identifiable becomes all the more important. Because in a case brought by the CPS, it will be, they have a set of criteria, not least in the Attorney General's guidelines on the acceptance of pleas, that they will be applying in that process, of which the victim's view will be only a clearly defined part. If the process is entirely in-house with the victim also being you, unless it's similarly delineated, then it becomes difficult to be sure that the process is applying the interests of justice.
Later in your report, I'm not going to ask you to turn it up now, you noted that the court in Asif and Ditter made clear that the fact that a private prosecutor has a motive other than only the pursuit of justice for their actions does not necessarily make it improper for them to bring a prosecution.
No, absolutely.
Given that in the cases that the Post Office prosecuted, the Post Office was also the victim, are you suggesting that even if the Post Office did not allow this to override its other prosecutorial functions, it was not entitled to consider whether continuing an investigation or prosecution was in its own business interests in deciding whether to proceed with the investigation?
No, it was clearly entitled to take that into account as a factor, but it could not be the reason either to prosecute or not.
And is it right that the interests of the business in the relevant policies are identified as only one of the factors to be considered?
Yes, although often they're the first.
Thank you. Can we turn to the initiation of proceedings? That can come down from the screen, please. For reasons you explained yesterday, the Post Office did not charge suspects, but instead initiated process by laying in information in the Magistrates' Court seeking the issue of a summons.
Yes.
And you address, if we turn up at page 83, Page 83. Get the report. Thank you. Page 83. Between paragraphs 185 at the foot of the page through to paragraphs 189, the procedural rules for the issuing of a summons and the laying of an information.
Yes.
I'm not going to ask you to repeat those, and I'm not indeed going to summarise them. I'm just instead going to take those passages as of your report as read. But on page 86, you tell us in paragraph 190 about some additional holdings or dicta of Mr. Justice Sweeney in the K case that we referred to yesterday.
Yes.
And can we look, please, at paragraph 190? You say that having identified that framework, that's the legal framework that I've just skipped over.
Yes.
Mr. Justice Sweeney then identified the duties of a private prosecutor in relation to the making of such an application. That's the application for the issue of a summons.
Yes.
So as to ensure that the court was able properly to approach those considerations. He observed that any applicant for a summons owes a duty of candour. Having reviewed the relevant authorities, he expressed that duty at paragraph 5 as, quote, one of full and frank disclosure, which necessarily includes a duty not to mislead the judge in any material way, and which requires the disclosure to the court of any material which is potentially adverse to the application or might militate against the grant, or which may be relevant to the judge's decision, including any matters which indicate that the issue, that's the issue of the process, might be inappropriate. As Lord Justice Hughes, as he then was, memorably put it in re Stamford International Bank Limited at paragraph 191, in effect, a prosecutor seeking an ex parte order must put on his defence hat and ask him what, if he were representing the defendant or third party with a relevant interest, he would be saying to the judge. And having answered that question, that is what he must tell the judge. So that's the explanation as to the law on the duty of candour when applying for a summons.
Yes.
Mr. Justice Sweeney then considered, in your paragraph 191, you tell us how the duty operated. At paragraph 37 of his judgment, he said, quote, in order to enable the court to properly carry out its duty to consider whether the application was vexatious, an abusive process, or otherwise improper, to consider whether to make further inquiries, to require the claimants to be notified of the application, and to hear the claimants, and the summons that had been issued was quashed. He observed at paragraph 38, as the case demonstrates, the grant of summonses, typically conducted ex parte, can have far-reaching consequences. Compliance with the duty of candour is the foundation stone upon which such decisions are taken. In my view, its importance cannot be overstated. In paragraph 192 of your report, you address the issue of the extent to which the duty of candour is addressed in any post office policy.
Yes.
You tell us that the Post Office Conduct of Criminal Investigations policy dated August 2013 addressed the obtaining of a summons as the mechanism for initiating proceedings, but there was no reference to the duty of candour.
No.
The summons and cautioning policy of October 2001 also addressed the obtaining of a summons to initiate criminal proceedings. That didn't address the duty of candour.
No.
You say that remained the case in the November 2005 revision of the policy. And then again, in the Royal Mail's Magistrates and Crown Court Procedures policy issued in May 2013, and in the Casework policy issued in June 2013, the procedure for obtaining a summons is described, and the circumstances in which it's appropriate are described, but neither refers to the duty of candour.
No, and so what I have done in paragraph 192 is set out, as best I can, every reference I could find to the initiating of proceedings by summons or the process of obtaining a summons. And so those are the examples I could find. And in none of them was there any reference to that foundation stone duty.
And the same applied to all of the training materials that address the issue of proceedings?
Such that I saw, yes.
Yes. So does it follow that in none of the documents that you've seen was the duty of the Post Office to be candid with a court addressed?
That's right.
Was that of concern?
It was. The risk is that the obtaining of a summons is viewed as a purely procedural or administrative function rather than being, as it is, a judicial exercise by a court. And the court, to carry that exercise, needs to consider the whole of the relevant circumstances. That is what the rules require of the court. But there's only one party involved in that process with the court, and that's the prosecution, unless, exceptionally, the court itself decided to hear from the other side. But they would only do that if they realised there was a need to. And so, again, that goes back to the party who is before the prosecution undertaking their duties properly, because it's a judicial process, not a tick box exercise.
Can you calibrate the level of your concern for us that the foundation stone, whose importance could not be overstated by Mr. Justice Sweeney, was not referred to in any of the policy or training material that was shown to you?
Well, clearly the central question is whether that foundation of the process was recognised by the Post Office in undertaking this task. That's to be judged by what they actually did. But the fact that nowhere in the materials that I had seen did they reference that duty at all is a very real concern, but because it's difficult where it's not written down anywhere to be satisfied that they understood that's what they were meant to be doing or were doing.
Thank you. Can we turn to a separate topic, please? I'm going to take this out of order.
Can I just mention, because it's been weighing on my conscience, that I corrected you as to the year of the Belmarsh Magistrates Court and Watts, and I was looking at two other cases where they'd got it wrong and you'd got it right. It was 99 and not 92. I'm very sorry.
8th of February 99, I think.
I'm not going to argue with that with you on that again.
Thank you. In fact, I think your argument was with Mr. Justice Sweeney for a misquote.
Yes, and I'll apologise to him in due course.
Yes, thank you. Can we turn to the separate topic of expert evidence? And I'm taking this out of order. It's in your second report, and we're interleaving it, essentially.
Yes.
It comes more in the process sequence of events. Your expert report is at EXPG 603. And what I'm going to do, if I may, Mr. Atkinson, is seek to draw out from the report, rather than take you to passages within it.
Yes.
Some themes,
yes,
if I may. Would you agree that, so the first topic is the duty of a prosecutor in first instructing an expert?
Yes.
So we're here focusing on the prosecutor, not the expert themselves. Before considering what duty a prosecutor may have to ensure that the expert understands his or her duties, would you agree that the prosecutor must provide the expert with instructions upon what it is that his or her opinion is sought?
Yes.
And should set out issues or questions that the expert is expected to answer?
Yes.
And should set out the material upon which reliance has been placed in the prosecution concerning that particular issue or issues, and which may be relevant to the questions which the expert is expected to answer?
Yes.
So they should describe the material or list it and provide it?
Yes.
Would you agree that throughout the relevant period, a prosecutor intending to rely on expert evidence in criminal proceedings was under the following obligations? Firstly, to satisfy themselves as to the expert's relevant qualifications and expertise.
Yes.
Secondly, to satisfy themselves that the expert had been appropriately instructed, including by the provision of a relevant and detailed letter of instruction or terms of reference.
Yes.
You hesitated slightly.
I hesitate because clearly the instruction needs to provide the expert with explicit guidance as to what it is they're being asked to do and what material they're being asked to consider in doing it. And that clearly is detail. It would be in a form of letter of instruction. It wouldn't have to necessarily be in a conventional letter. It could be done in an email format, but it would need to be done in a written format, because the expert in due course would have a duty to make clear what their instructions had been. And so just over a personal example, setting out, as I do at the beginning of my report, what it was I was being asked to report on.
Yes. The prosecutor would be under a duty, would this be right, to inform the expert as to their, i.e. the expert's, relevant duties to the court?
That is the question that I wrestle with in this report. It is, my view, borne out by the practice of, by way of example, the Crown Prosecution Service and the Health and Safety Executive, that is part of the prosecutor's duty, because it is unquestionably part of the prosecutor's duty to ensure that that is done by an expert that they rely on.
Fourthly, would there be a duty on a prosecutor to satisfy themselves that the expert had firstly understood and secondly complied with their relevant duties to the court?
Yes, both because the criminal procedure rules, as I read them, required them to, and secondly because it was necessary for them to make sure that had been done for them to be satisfied that the evidence was going to be admissible. And there was little point obtaining evidence from an expert that wasn't actually going to go anywhere near a courtroom.
Fifthly, the prosecutor was under a duty, would you agree, to satisfy themselves that any material or literature of which they are aware and which may undermine the expert's conclusions has been reviewed by the prosecution and, if appropriate, disclosed to the defence and the expert?
Yes.
Would you agree that a prosecutor was under a duty to bring to the attention to the defence and to the court any material of which the prosecutor was aware which was reasonably capable of undermining the expert's opinions?
Yes.
And that might be matters concerning the expert's qualifications and experience.
Yes.
The factual basis on which the expert had reached his or her opinion.
Yes.
And more generally, the expert's credibility.
Yes. And so by way of example, if an expert who you propose to rely on has been criticised in ways that undermine their expertise or their credibility in a previous court case, you are required to disclose that.
And so, drawing those threads together, if a party is obtaining expert opinion and proposes to call a person as an expert witness, the purpose of that is to obtain their opinion on an issue or a question which has been identified to the expert.
Yes.
Can we turn to the duty to ensure that experts understand their duties? I think you addressed this in paragraph 63 of your report. On paragraphs, page 30, paragraphs 62 and 63. Page 30. Thank you. You tell us there is no question but that the law does impose duties on expert witnesses, and the expert owes their duties to the court to ensure their compliance with these duties. This was well established in the civil context through, for example, the Icarian Reefer case, and in the criminal context, and you name a couple of other decisions.
Yes.
You say it follows that by at least 2005 to 2006...
Which is the date of those cases.
Yes, of Harris and B.T.
Yes.
Any investigative and or prosecutorial authority should have been aware that any expert instructed owed their primary duty to the court, and that they were required to meet a series of requirements as to the content of their report, their underlying material and their conclusions. This was supplemented following the introduction of the 2010 criminal procedure rules by the duties of experts that were set out therein. You say, I've not identified in any post office policy documents with which I've been provided any analysis of these obligations or their implications for post office investigations. And does that include both policy documents and training documents?
Yes. There's very little reference to expert evidence at all in the material that I've seen.
Would you go further and say that if a prosecutor wishes to rely on an expert, the prosecutor is bound to ensure that the individual concerned actually understands that they are to give evidence in the capacity of an expert?
Yes.
And that carries with it special duties?
Yes. And the first is because of the second.
And that then, does it follow that the prosecutor, is therefore duty bound to inform them of their duties?
Yes. Because
otherwise there's a risk that the expert may not know what their duties entail.
No. And the bedrock of that is that, so that it's understood, is that the expert is an independent voice. They are there to bring their expertise, independent of who is instructing them, to bear on the issue they're instructed to give their expertise about. And they owe their duty not to the person who's instructed them, but to the court in which they're giving evidence. And it is a particular position that carries with it particular responsibilities, and they are of such importance that it's essential that they understand them.
Was there any different approach or any added duty where the proposed expert was not functionally independent from one of the parties in the case?
I think in that situation, the requirement to make sure they understood the role that they were being instructed in and the role that they would be performing in the proceedings was all the more important because their independence in such circumstances needed properly to be understood by them. They were not helping their employer, they were giving independent evidence to a court that they owed a duty to.
And so dealing with issues at a level of generality at the moment without going to the facts of any of the 20-odd cases
Yes.
that you're to come back to speak about. In the case of the Post Office seeking to call witnesses from Fujitsu Services Limited to provide opinion evidence, would you say whether they were subject to that added duty or particular duty that you just mentioned to ensure that such individuals knew that they were being called in the capacity of expert and therefore the duties to which they were subject?
Yes.
Would that be because witnesses from Fujitsu wouldn't be akin to a conventional expert who was accustomed and trained to providing expert evidence and was part of, for example, an expert witness institution or a professional body and so forth?
Well, it would be proper practice to, with that latter category of person, to make sure, even if you were preaching to the choir, to make sure that they understood what their duties and obligations were, even if that's what they did for a living and they knew them already. You were duty bound to make sure they did by telling them. And where there was a risk that they may not appreciate that is the capacity in which they are being asked to give an opinion, then it's all the more reason to make it absolutely crystal clear to them that is the capacity in which they're being asked for their opinion, and that they have duties as a result of that.
And might that that risk be triggered, especially where the person involved, their day job is not being an expert witness? They weren't a conventional expert in the sense that they were completely independent of the subject matter that they were going to speak about.
Yeah, that's right.
And indeed that they were going to speak about some of their own work.
Yes.
So I wonder whether we could take the morning break there. I appreciate we started 7 or 8 minutes late this morning, but that would be a convenient moment.
That's fine, Mr. Beer. What time shall we recommence?
22, please.
Very well. Fine.
Thank you. So good morning. Can you continue to see and hear us?
Yes, I can. Thank you.
Thank you, Mr. Atkinson. Can we turn up, please, RLIT 40172? This is an extract from Archbold Criminal Pleading Evidence and Practice. It's going to come up on the screen for you. RLIT 40172. Thank you. And this is from the current 2023 edition.
Yes.
I should make it clear. And can we turn to page 14, please? Oh, I'm told it's only 9 pages. Can you scroll forward, please, to the bottom page number, which is 1694. So at the bottom of the page, there's a page number 1694. I think what that means is somebody has scanned in every other page. just the odd pages, not the even ones. And I'm looking at an even page number.
I have the page as well, if that helps.
I'll read it out for those. That can come down from the screen. Thank you. I'm reading from page 1694, one of the odd page numbers in Archbold, at paragraph 10.25. And it says, quote, "It is the duty of an expert instructed by the prosecution to act in the cause of justice. It follows that if an expert has carried out a test which casts doubt on his opinion, or if such a test has been carried out in his laboratory and is known to him, he's under a duty to disclose this to the solicitor instructing him, who has a duty to disclose it to the defence. This duty exists irrespective of any request by the defence. It's not confined to documentation on which the opinion or findings of the expert are based. It extends to anything which might arguably assist the defence. Moreover, it is a positive duty, which in the context of scientific evidence obliges the prosecution to make full and proper inquiries from forensic scientists to ascertain whether there is discoverable material. See Ward, 1993, 96 Criminal Appeal Reports. 1. That statement of the law, although it's included in a 2023 edition of Archbold, would you help us? Does that statement of the law cover the entirety of the relevant period?
Yes.
And so it tells us that an expert instructed by the prosecution has a duty to act in the cause of justice. What do you understand that to mean?
That an expert owes their duty to the court to do what they can through their expertise and their opinion to ensure that that court performs its function correctly in terms of the acting, where it's a criminal court, in the interests of justice. And so if the expert is aware of material that would undermine either their own expert opinion or the premise as communicated to them in their instructions of the prosecution, then they're duty bound to say so.
Secondly, it tells us that the prosecution has a duty to make full and proper inquiries
Yes.
Of prosecution expert witnesses in order to ascertain whether there is any discoverable material. Are you aware of any Post Office policy, guidance or training which reflected either of those two principles in the documents that you have seen?
No, not that I can think of.
Can I turn, please, to the necessary contents of an expert report? On page 8, at paragraph 15 of your volume 1A report, so that's EXPG 603. Page 8, thank you. You cite a summary of the duties of experts that originally appeared in the Icarium Reefer case,
Yes.
a civil case,
Yes.
as essentially transposed into the common law insofar as it affects criminal proceedings. Is that right?
Yes.
And so what are described as the necessary inclusions in an expert report, and there are 7 of them that are then set out. From what date were these necessary inclusions in an expert report in criminal proceedings?
The Icarium Reefer case, which was a civil decision but was a decision in 1993, what was seeking to set out that which it was already recognised in effect were the necessary inclusions, but it conveniently set them out together. They were then picked up on by the Court of Appeal in 2005 in a case called Harris, which was a decision of Lord Justice Gage, who referred to them as being established as the necessary inclusions. And then, in this case, BT, in a meeting of minds, Lord Justice Gage, who had given the decision in Harris, was sitting with Mr. Justice Cresswell, who'd given the decision in Atkinson Reefer, and they restated them. So certainly by this time, by 2006, these were necessary inclusions, but they were not new in 2006. They were recognised already.
Thank you. One of the 7 requirements was a statement to the effect that the expert had complied with his or her duty to the court to provide independent assistance by way of objective, unbiased opinion in relation to the matters within his or her expertise. Is that right?
Yes, number 6 on the list.
And so by this time, at least 2006, there ought to have been set out on the face of the report a statement by the expert that they had complied with these duties.
Yes.
Would you agree that these requirements aren't related to the format of an expert report, but go instead to whether substantively the report and the expert have conformed to the fundamental requirements of an expert and an expert report?
Absolutely.
So they're issues of substance and not form?
Yes.
Given the characterisation of the matters to be included was that they were necessary inclusions, would it mean that a failure to include them and a failure to comply with them may render a report inadmissible, or at least capable of being excluded from evidence under Section 78 of the Police and Criminal Evidence Act?
Yes. And I should say that if they were not included in written form, but it was possible for the party seeking to rely on the expert to demonstrate that they had nevertheless been complied with, then that may not result in the exclusion of the evidence. But so it is both the substance of it and the form of it.
And so the significance of Harris and BT, Thomas I think is the full name of the case, lies not just in the reiteration of the application of the Atkinson Reefer principles to the criminal law, but also that they became required to be stated content in an expert report.
Yes.
And emphasise the need for the expert to demonstrate an understanding of what their duty of independence entailed.
Yes. And the fundamental nature of them is underlined by the fact that they were then incorporated into the next major review of the criminal procedure rules. So it was considered that these were fundamentals that needed to be included in any expert report.
And on that, it might be a footling point, but in your report you say that Criminal Procedure Rules Part 24 was replaced by Criminal Procedure Rules Part 33 in 2010. I'm not going to go through all of the detail, but might it be the case that Criminal Procedure Rule Part 33 was introduced with effect from the 6th of November 2006, i.e. immediately after, the year after Harris and BT?
Certainly by the time again, this was an area where it was I was reliant on what I could find. Certainly by 2010, Rules 33 were there, which incorporated this. I'm perfectly willing to accept that they appeared earlier than that. Indeed, it would make sense that they did.
For aficionados, it's Schedule 1 of the Criminal Procedure, open brackets, Amendment Number 2, close brackets, Rules 2006/2636. which introduced by their Schedule 1 the new Criminal Procedure Rules Part 33 coming into force on the 6th of November 2006. Thank you. That can come down from the screen. Thank you. Can we turn to the topic of disclosure, moving away from expert evidence? Can we go back to your first report, EXPG 602, and turn to page 95, please? Yep. And it's at the foot of the page under the heading Disclosure. And you tell us in paragraph 213 that the prosecution's obligations as to the disclosure of unused material to the defence is governed through a combination of the CPIA, the code issued under the CPIA, and the Attorney General's guidelines.
Yes.
And then in paragraphs 214 to 217, you tell us about the history which led to that position, including instances of injustice caused by material non-disclosure by the prosecution.
Yes.
I'm going to take those paragraphs as read, if I may.
Yes, of course.
And then from paragraph 218 onwards, on page 98, you tell us about the application and operation of the CPIA. And again, can I try and summarise this to cut through the material that you've helpfully included? And tell me whether you agree or disagree with my summary or want to supplement it. Firstly, the relevant provisions of the CPIA, the Act itself, relating to disclosure, and that's principally Part 1 of the CPIA, are of deliberately wide application so that they they capture any criminal investigation, and they therefore apply directly to the Post Office's criminal investigations and prosecutions at all times throughout the relevant period.
Yes.
Secondly, the golden rule, as it was described, was that the Act and fairness required full disclosure of all material held by the prosecution that weakened its case or strengthened the case for the defence.
So as originally enacted, it focused on material that would undermine the prosecution, or that might undermine the prosecution case. From at least 2005, it also addressed material that might assist the defence case.
Thank you for that qualification. And then, thirdly, and we can turn up a paragraph for this because it's best that I read it rather than try and summarise it. It's on page 99. Paragraph 224 at the foot of the page. It follows that the prosecutor's duty arises from material in his or her possession rather than material in the possession of a third party. The prosecutor's obligation to disclose material in the hands of third parties only arises if and when that material has come into the possession of the prosecutor, and at this early stage, when in the opinion of the prosecutor, it might undermine the prosecution's case. That's the clear import of Section 3. The procedure for seeking to obtain material from third parties is not governed by the CPIA itself, but as will be seen by the Attorney General's guidelines. The Act does not therefore identify the test to be applied when consideration is given to whether third-party material should be obtained.
Yes.
And then fourthly, the Act made provision for continuing duties of disclosure in slightly different terms as before the 4th of April 2005, as opposed to all times after that.
Yes.
Including in response to a defence statement.
Absolutely.
But there was a continuing duty of disclosure throughout the relevant period.
Yes. And so the presumption being, therefore, that after disclosure had been made by the prosecution, the defence would set out the nature of their case in a document, a defence statement, and that the prosecution would then respond to that with any disclosure that arose from it. But that whether that defence document was received or not, there was still a duty on the prosecution to keep their disclosure under review.
Thank you. Then the second source of obligation is the code.
Yes.
And I think you tell us that the code makes 3 additional points that you identify in your paragraph 232 to 235. So that's page 103, please. 232 at the foot of the page. You tell us the code, so this is the code under the CPIA, then addresses the interaction between the investigation and the prosecution and between those responsible for each. The first area is in relation to the obtaining of advice. Paragraph 6.1 states, quote, the officer in charge of the investigation, the disclosure officer or an investigator may seek advice from the prosecutor about whether any particular item of material may be relevant to the investigation. And so what's the point that you're making there by reference to the code?
So what the code seeks to do in this respect is to make the disclosure process identified in the Act work by identifying those who are playing roles in that process and how they should work with each other. And in this particular respect, it is dealing with the situation where those involved in the investigation who have duties in terms of the identification of material that may be relevant and therefore may be disclosable should have recourse to the prosecutor to get their advice about anything they're uncertain about, so that there is that dialogue and that they should understand that uncertainty should result in the seeking of advice.
You continue, the second area is once a schedule of material has been produced, the disclosure officer is required, see paragraph 7.1, to provide that schedule to the prosecutor when submitting the case to them and to draw to the prosecutor's attention, quote, any material an investigator has retained, whether or not listed on a schedule, which may satisfy the test for prosecution disclosure in the Act, and should explain why he has come to that view.
And so this is in the 3 R's that we talked about yesterday. I'll try and get them right this time, of record, retain and reveal. This is the reveal stage where the investigator is setting out the material that might fall to be disclosed for the prosecutor to then carry out a review of. And it's an essential audit and safeguard to make sure that disclosure is undertaken properly and that the investigator has been doing their job properly.
And over the page, please, at 233, they make a third point. Additionally, the disclosure officer is required to provide any of the following not otherwise included in the above submission, quote, information provided by an accused person which indicates an explanation for the offence with which he has been charged, any material casting doubt on the reliability of a confession, any material casting doubt on the reliability of a prosecution witness, and any other material which the prosecutor believes may satisfy the test for prosecution disclosure in the Act. And you comment, this is an important requirement because it envisages that material that undermines the investigation in important respects, such as undermining the reliability of a key aspect of the case of an accused, will be volunteered to the prosecutor at the outset and flagged up as such.
Yes. And because the prosecutor needs to assess the reliability of evidence as part of their decision as to charge and their continuing review of that, and because the prosecutor has to ensure that there is disclosure of material that undermines or might undermine the prosecution case to the defence, the upfront nature of this requirement that the investigation is volunteering material in those categories or relevant to those categories to the prosecutor is of central importance.
Thank you. Can we go to the third source of law, or the third obligation, namely the Attorney General's guidelines and on disclosure? And you address these at page 110 of your report.
Yes.
And this is a very 110, thank you, under the heading the AG's guidelines. This is a very substantial section of your report.
Yes.
It runs right up until paragraph 290. Again, some summaries, if I may, to
Yes,
see whether you agree or disagree before looking at some of the content of each iteration of the guidelines. Firstly, the guidelines were introduced in 2000 and applied throughout the relevant period being examined by the inquiry.
Yes.
Secondly, would you agree that the purpose of the guidelines was stated to be improving the operation of the arrangements for disclosure, and in particular addressing the roles of the participants in the disclosure process? And that statement was made after research had been undertaken as to the operation or misoperation of the CPIA.
Yes, and so it had been recognised, and the CPIA had not been operating for that long, but it had been identified that it in itself and the code under it in itself were proving not to be sufficient to make sure that its objectives were being satisfied and proper disclosure was being made.
And the third point is that the guidelines applied to prosecutions commenced at the instigation of the Post Office, just as they did to prosecutions commenced by other prosecutors.
Yes.
And fourthly, the importance of the compliance with the guidelines was emphasised in a series of cases time and again throughout the relevant period.
Yes.
I'm not going to take you to the purple prose used by the courts on each occasion, but is that summary sufficient? Absolutely.
And the fact that the courts had so much recourse to the guidelines as an exposition of what the requirements were and why they mattered serves to underline how important the guidelines have always been as a central part of the disclosure framework.
If we can turn then and look at some content of the guidelines, starting with the 2000 iteration, and that's page 112. And between paragraphs 254 and 264, you address the content of the 2000 guidelines.
Yes.
Are there any particular points that you would wish to emphasise about the content of the 2000 guidelines?
Perhaps the most striking thing about them is, which I suppose in one sense is unsurprising given they're written by the Attorney General, who has a supervisory role in relation to prosecutions, that they are very clear as to the responsibilities and duties of prosecutors in order to make sure that disclosure works properly, which involves not only their own decision making but their superintendence and supervision of those who've undergone the investigation before it reaches them.
Thank you. I'm going to take the content as read in the interest of time.
Yes, of course.
Can we move forward to the 2005 iteration of the AG's guidelines? That's page 117.
Yes.
And you address the 2005 guidelines between paragraphs 265 to 274. And again, I'm afraid it's a rather open question. Are there any particular points that you would emphasise about the 2005 iteration of the guidelines?
So the 2005 guideline was brought in because the test for disclosure had been changed by the Criminal Justice Act 2003 so that it involved both material that might undermine the prosecution case and material that might assist the defence case. And so it was designed to address that. It was designed also to engender a greater dialogue in relation to disclosure so that it wasn't just a matter of prosecution decisions in abstract, but also prosecution decisions taking account of the defence case as identified, for example, in a defence statement. And thirdly, it was the beginnings of real attempts to grapple with the difficulties of disclosure where there's material held on computers, and therefore the review of that material for disclosure is a more arduous task.
Thank you. Again, I'm going to take the content of the guidelines as read. I think the next version was 2013, which is right at the end of our relevant
yes.
period. and you address that at paragraph 285 and following. I'm therefore not going to ask you for any supplemental views on that. I think it's right that between the second and the third edition, supplementary guidelines on digitally stored material were issued in 2011.
Yes.
You address those at page 120, at paragraph 275 and following. Again, the open question, anything in particular on the supplementary guidelines that you would wish to emphasise beyond that which is in your report?
So again, that this is specific guidance which is designed to address how an investigator and how a prosecutor are to go about complying with their obligations where there is a very large amount of material stored on a computer. It's designed to be practical to make that achievable, but underlying, of course, that there is the obligation to do it and to ensure that a fair result derives from that process.
Thank you. So we've looked at the three sources of law as I've described them. Turn to the Post Office's policies.
Yes.
You address these from paragraph 237 onwards at page 105, please, if we can look at page 105. And you address the Post Office policies between paragraphs 237 and 243.
Yes.
In 237, you tell us that the Post Office casework management policy of March 2000 makes reference to the CPIA at a number of points. It's of note that paragraph 3.3 specifically refers to the retention periods for evidential material. And both in the 2000 iteration and in the February 2000 iteration, this required full details of, quote, any failures in security or operational procedures are identified, which may or may not be directly connected to the offence, to be included in the investigation report. Just stopping there, could you ascertain from the policy whether the investigation report was itself a disclosable document?
There was debate within the paperwork that I've seen as to whether it was or not. It's a feature of many of the 20-odd cases that I'll be coming back to talk about in relation to Volume 2, but it's effectively the document that went from the investigator to those who made decisions as to whether the person under investigation should be suspended and whether the person under investigation should be prosecuted, and was usually the document that appeared to be relied on by the person making the charging decision. And it's not clear from what I've seen as to whether it was regularly disclosed, and there are certainly instances where it wasn't, and a decision was taken that it wasn't disclosable.
Thank you. You continue that the policy adds, quote, the issue of dealing with information concerning procedural failures is a difficult one. Some major procedural weaknesses, if they become public knowledge, may have an adverse effect on our business. They may assist others to commit offences against our business, undermine a prosecution case, bring our business into disrepute, or harm relations with major customers. Unless the offender states he's aware that accounting weaknesses exist and he took advantage of them, it's important not to volunteer the option to the offender during interview. Just in relation to the sentence that if weaknesses become public knowledge, they may have an adverse effect on our business because they may undermine a prosecution case. Is that a reason not to reveal them?
No, if there's material that undermines a prosecution case, then it is disclosable rather than the contrary.
Is the fact that making public knowledge may bring our business into disrepute a reason for non-disclosure?
No.
Is the fact that revelation may harm relations with major customers a reason for non-disclosure?
No. And so there are situations, taking a step back from this, where there can be competing public interests where, for example, revealing failings in an investigative technique would have the consequence of revealing what that investigative technique was, which might frustrate its use in other cases, and it would be a decision as to where the public interest lay, and that might involve having recourse to a judge for the judge to decide whether the interest of justice required its disclosure. But you are there talking about things that might undermine the effectiveness of the criminal investigation process generally. You are not talking about issues of reputation or customer relations.
Moving to paragraph 238, you tell us that the disclosure of unused material, criminal procedure and investigations Act 1996 Code of Practice that was issued in May 2001 was 3 pages long. It addressed the roles of the investigator and disclosure officer without specific cross-reference to the CPIA code. You tell us that an investigator by paragraph 3.2 is someone who is, quote, involved in the conduct of a criminal investigation involving consignia, who has a duty in particular to record and retain information. They share a duty with the disclosure officer to be fair and objective and must work together with prosecutors to ensure that disclosure obligations are met. Over the page, the disclosure officer is the person, quote, responsible for examining material retained during an investigation, revealing material to legal services during the investigation, and certifying to legal services that he has done this. You say, and it's a point you made yesterday, that by contrast to the CPIA, the policy proceeds on the basis that the investigator and disclosure officer will normally be the same person.
Yes.
The policy states that the disclosure officer should inspect, view or listen to all material retained, save where a large amount has been seized. In such circumstances, the existence of the material should be identified to the defence. And lastly, the disclosure officer should ensure that a description of the unused material is sufficient for the prosecutor to review it and should draw to the prosecutor's attention any material about which they are in doubt. In relation to the point that the disclosure officer and the investigator will normally be the same person, would you agree that the CPIA code does allow for this?
Yes.
And allows the officer in the case and the disclosure officer to be the same person?
Yes.
Would you agree that even in cases investigated by the police and prosecuted by the CPS, for many cases, and perhaps the majority of more minor or smaller cases, the disclosure officer would regularly be the officer in the case?
Yes.
Given that it may be common practice for the functions to be performed by the same police officer in many cases, prosecuted by the CPS, and we're here dealing with a private prosecutor, and there's nothing in the CPIA to prevent it, would you accept that having the function of disclosure officer held by the investigating officer is neither contrary to the law nor practice applicable to the these private prosecutors during the relevant period?
Yes. I highlighted it because, first, that it was predicated here as being normal rather than an option, and secondly, because of a concern that in a case brought by the Crown Prosecution Service on the basis of an investigation by the police, there are still those two separate agencies involved, and so there is that independent scrutiny of the disclosure process by the CPS in those cases, where it is all being done by the same organisation, that there would be merit in there being more of a delineation of roles to ensure a proper scrutiny exercise. That was my only concern.
Thank you very much. Can we just scroll forward to paragraph 240, please? Here you're dealing, as opposed to policies, with training material, and you say that you have seen a range of training workbooks along with an undated document entitled Criminal Investigation, which addresses 9 e-books which represent the theoretical learning from the Investigation Foundation course. And you say that in combination, they show that there was no specific training in that package in relation to the CPIA or disclosure. There was a workbook about investigators' notebooks. And just stopping there, do investigators' notebooks seem to be a particular issue that crops up again and again in these policies?
Yes.
It seems to be a particular focus of attention.
Yes.
In any event, that did not refer to the duty of retention. It didn't refer to the CPIA, nor did it refer to the 2001 policy document.
No, that's right. I should mention for completeness that I have, in material recently provided to me, seen some further training material, including I think a 2010 presentation on disclosure, although it was not clear to me who that presentation was intended for.
Did that improve upon this training material that you summarise in paragraph 240?
It took whoever it was given to through the CPIA obligations in terms of the duty of disclosure and so on, and made reference to the code. It didn't, though, refer to the guidelines, the Attorney General's guidelines.
And then lastly on this topic, if we can go forward, please, to page 120. And look at paragraph 274. This is after you've summarised the 2000 and the 2005 AG's guidelines.
Yes.
You then turn in this paragraph to see, well, how well were they reflected in Post Office material. And you tell us that although the disclosure of unused material, CPIA 1996 Code of Practice, issued in May 2001, did allude to the original version of the AG's guidance, you hadn't seen any amended version of that policy following the 2005 guidelines until the 2010 revision. That 2010 document referred to the 2005 Code of Practice, but not the AG's guidelines alongside it. No materials addressed this important revision to the guidelines.
No, so the 2001 document said, in the light of the Human Rights Act, the Attorney General has issued new guidelines on disclosure of unused material. The guidelines clarify the responsibilities of investigators, disclosure officers, prosecutors, and defence practitioners, full stop. And that was the extent of the application of a detailed document in that policy. Of course, I don't know, because I don't know what was on the database as to whether the guideline was there. When that disclosure of unused material policy was updated, the reference to the guidelines was removed.
So that's slightly counterintuitive.
Yes. And so I couldn't detect evidence of explicit updating of policy to reflect the guidelines, but I did detect the removal of the guidelines from the policy.
That can come down from the screen, thank you. And so it is a summary, a high-level summary of the position that although you have seen Post Office policies in relation to disclosure in investigations, you have not seen any prosecutorial policies that in relation to disclosure.
There is reference within both the 2001 and 2010 disclosure of unused material policies to what is described as prosecutors' guidelines. They're half a page of bullet points which reflect aspects of that which is contained in the combination of the CPIA and the code thereunder. But there's no separate, that I saw separate prosecution guide policy as to how prosecutors were to undertake their disclosure responsibilities, their responsibilities for the supervision of the investigation and ensuring that disclosure was undertaken appropriately and fairly.
We, to update you, now have a witness statement from a senior member of the criminal law team, Rob Wilson, who in his statement says that, quote, no guidance in relation to disclosure obligations was given in any prosecution policy documents. I believe that the policy and standards team within the Post Office security were responsible for providing written guidance and training with input from me. It was felt that as the code for Crown prosecutors did not provide guidance on disclosure, that this should be dealt with in a separate document. Firstly, have you seen any policies that were provided by the Post Office policy and standards team concerning disclosure obligations to be discharged by prosecutors?
I don't think so. I can't think of any.
Yes, thank you. Can I turn to the topic of third-party disclosure, please? You addressed this issue between paragraphs 294 and 332 of your report, starting on page 128. Page 128. And again, some high-level points, if I may. Is it right that you did not identify any Post Office policies in the relevant period that addressed the obtaining of third-party disclosure?
That's right.
And that applies both to investigative duties and prosecutorial duties?
Yes. Or
duties owed by an investigator and duties owed by a prosecutor?
Yes.
Was that a concern?
Yes. It was recognised that, as one of the things that the CPI and its code did not address, that to ensure fair proceedings in the interests of justice, it is not enough for a prosecution to make disclosure of that which it already has, because there may well be material that is beyond what it has that will nevertheless undermine its case or assist that of a defendant, or that might undermine its case or assist that of a defendant. And so what the Attorney General's guidelines sought to do was to make it absolutely clear that there was that obligation on investigators and prosecutors to think outside the box of what they already had as to what they might need, and to ensure that they were doing all that they could to make sure that the proceedings were fair by not blinkering themselves as to just looking at what they already had, but to think what else might be necessary. And that's what third-party disclosure is all about, that process of thinking about whether there is material beyond what you've got that you ought to obtain if you can, and then review that material for disclosure in the same way as what you have already got. And you do that because you need to ensure the process is fair. If there is nowhere written down for you as an investigator or for you as a prosecutor that that is what you need to do, there is every risk that you will overlook it, that you will think, I have done what I'm required to do because I have looked at the schedule that the investigator has provided me, I have reviewed the material that my investigation has generated, and I have done what is required by the code and by the Act in relation to that. That would not be the end of your job, but if there's no reference in your policies to it being a part of your job, you may think it is.
Could we turn to paragraph 306 of your report, which is on page 133? Where you cite a passage from the speech of Lord Bingham in the House of Lords in the case of the Crown against H and C, where he said, if material does not weaken the prosecution case or strengthen that of the defendant, there's no requirement to disclose it. But then this, for this purpose, the parties' respective cases should not be restrictively analysed. Is that a feature of the conduct of criminal investigations and prosecutions, that when making decisions on disclosure, the prosecutor must not restrictively analyse the case of the defendant?
Absolutely. It may be, to take a case away from any that we're concerned with here, that there's an allegation of assault and the defendant is saying, I was acting in self-defence. If there is material that would not just undermine the prosecution case or support his case in relation to that, but also calls into question whether proper procedures had been followed and fair practices adopted in relation to some other aspect of the case against him, or if there was material that undermined the credibility of the prosecution witness in other respects, or other material that could provide the defence with a completely different layer of argument as to the admissibility of evidence or the fairness of the proceedings, then those are all things that the prosecution need to be including in their process of assessment as to whether material undermines its case or assists the defence. Not least because the defence may not identify as something that will assist them, something that they don't know anything about.
Thank you. That passage or that report can come down from the screen. Thank you. Is it right that the concept of corporate knowledge operates in respect of material which may meet the disclosure test and which is within the knowledge of any arm of the prosecution authority?
In the sense that a prosecuting or investigative agency knows something because of other cases that it has dealt with, but which has a relevance to the case they're now dealing with, yes.
Would that concept operate in the context of the Post Office acting as private prosecutor to mean that the Post Office's disclosure obligations extended to material within the control of the Post Office, whether or not that material was actually in its possession or not?
Yes.
And that phrase that I've used, material within the control of the Post Office, would that require any legal obligation on the party that physically possesses it to deliver or provide it to the Post Office?
It would depend on the nature of the control that the Post Office had. If it was something that other party were obliged to provide to them if they asked for it, for example.
Under a contract, for example.
Under a contract, for example, then it is material that the Post Office would be easily able to obtain and therefore should obtain. There are always complications in relation to third-party material that the only route to that you as a prosecution have to access is where you obtain a witness summons against that third party to hand over the material, because there are particular and specific criteria for the obtaining of a witness summons, and that third party would be able to litigate whether you had met those criteria or not. But that, on the scenario you're positing, wouldn't arise. This is separate from that, and therefore easier.
And so one might regard material within the control of the post office pursuant to a contract as material that it had an obligation to obtain and to disclose, rather than being a case of third-party disclosure.
It certainly had the obligation to obtain it. It then had to apply the disclosure test to it. And the point that I was seeking to make at this point, at the point we were just looking at in my report, is that there are those two stages. What the Attorney General's guidelines makes clear is that where an investigator or a prosecutor identifies that a third party might have material that might prove to be relevant to the issues in the case, they have a duty to seek to get it so that they can then decide whether it's disclosable or not.
Thank you. Are you aware of any post office policy, guidance or training document which address the issue that we've just discussed, i.e. material within the post office's control but not within its physical possession?
No, I don't think so.
Are you aware of any post office policy, guidance or training document that you've seen which assisted in the application of the parties' cases not being restrictively analysed principle?
No.
Would you agree that the disclosure obligations that arise under sections 3, 7 and 7A of the CPIA are imposed upon and are personal to the prosecutor?
Yes.
And therefore responsibility for ensuring compliance with the obligations that arise rest with the prosecutor, who in one of the cases is said to be in the driving seat.
Yes.
At the stage of disclosure.
Yes.
And even in the case of third-party material, the decision as to whether such material is to be obtained and is to be disclosed must be taken by the prosecutor.
There is an expectation that that process will have already been gone through once by the investigator, but the prosecutor's role is both to check that it's been done and either where it's not been done at all or properly, or they identify a wider pool of potential material for them to do it as well.
If it got to the stage that the investigator had not done it, for example, the prosecutor, would this be right, would not be able to, in effect, subcontract out to the third party the question of whether material is relevant and falls to be disclosed?
No. And one of the cases that I refer to in my report, a case called Alibi, was a case very much on that topic, which was where a prosecution was predicated on material from a company. There was a difference between how the prosecution went about getting material from that company on the one hand and what it then did in terms of its disclosure obligations on the other. And the disclosure obligations were for them, not for the company.
Would you agree that if the post office required information about the operation and functioning of the Horizon system, in a case where a postmaster, for example, made allegations about its faulty operation in a given case, the correct approach would be for a formal request at an organisational or an institutional level being made to the operator of that system, Fujitsu?
It would depend on what the setup was. One could envisage that where, on the scenario you posit, a postmaster has said something to that effect in interview, that it would be for the investigation, as part of the investigation, to make contact with whatever their liaison was with Fujitsu to make inquiries of them. if there was a comparable liaison arrangement at a prosecutorial level for that to be used, but if that route either was not available or was not working, then yes, absolutely, at a higher level.
In any event, in the case of post office prosecutions, the post office, would you agree, was required to consider whether Fujitsu was in possession or likely to be in possession of disclosable material and request that material from Fujitsu?
Yes.
Either pursuant to the any contractual arrangements, and I think we'll come back to those in part two, but if necessary by issuing a witness summons or even seeking a production order.
Yes.
Is the cost of obtaining material a relevant consideration in deciding whether to seek material from either a third party or an organisation over which you have control in terms of the disclosure of documents?
Not in those ball terms, no.
And why not?
Because your obligation is to undertake appropriate and fair disclosure, and that is not a cost-benefit analysis. That is a hard and fast obligation. How you go about it, because there's always a margin of appreciation as to exactly how it is done, providing the result is fair, you may be able to take account of cost where there are different routes that will achieve the same ultimate objective, but only if they achieve the same ultimate objective. And the cost may come into play in the sense that if you come to the conclusion that to satisfy your disclosure obligations will be enormously costly, you may make the decision not to prosecute for that reason, but that is the decision you would have to make. You can't go ahead and prosecute knowing that you haven't undertaken your disclosure obligations properly because it costs too much.
Thank you. Can I turn before the lunch break to a separate topic, which is Section 69 of the Police and Criminal Evidence Act 1984. In broad terms, can you confirm that the purpose of Section 69 was to enable the admission into evidence of a statement contained within a document where that document had been produced by, for example, a computer?
Yes.
That might include something like a readout from an intoximeter or even a receipt produced from a till?
Yes.
I think it's right that concerns were expressed by the Court of Appeal before the repeal of Section 69 that its operation had been misunderstood. Is that right?
Yes.
And as you have included in your report, the Law Commission made a recommendation for the repeal of Section 69.
Yes, so Section 69 had created certain precursors before a statement in a document produced by a computer could be admissible. It was recognised by the Law Commission that was, particularly if misread as meaning if you're relying on anything to do with a computer, you needed to go through that process, had become incredibly cumbersome, and so they looked to see whether it was actually necessary and concluded that it was not.
And the Law Commission undertook a consultation exercise.
Yes.
The nature of which you set out from page 90 onwards of your first report. So
yes.
EXP 602.
And it was a consultation on a wider range of topics than just Section 69. It was dealing with hearsay.
It's mainly about hearsay.
But it included a section on whether Section 69 was fit for purpose or not.
And it's paragraph 200 at the bottom. And so there was a consultation exercise commencing in May 1995 with the Law Commission's consultation paper 138, yes?
Yes.
And the problems with Section 69 were summarised by you in your little A and B there, is that right?
Yes.
And one of the respondents to the Commission was the Post Office.
Yes, it was.
And you addressed that in your paragraph 206 on page 92. With a letter, the author of whom is redacted in the copy that both you and I have, from the Post Office to the Law Commission, which said, quote, a large number of sub-postmasters now complete their cash accounts and other accounting records by using a computer. The sub-postmaster is often the only person working in the sub-post office or the only person who uses the computer. In the event of the sub-postmaster being prosecuted for theft or false accounting, the Post Office may need to rely on the computerised accounting records. The sub-postmaster is frequently the only person who can give the evidence required by Section 69. In the absence of admissions or other direct evidence, the Post Office may not be able to prove the case solely on the ground of being unable to satisfy the technical requirements of Section 69. Computers are now being used within branch offices, parcel force depots and Royal Mail sorting offices. You comment over the page, please, at paragraph 207, that this submission is of note because it's predicated on the basis that the person best placed to attest to the operation of the Horizon system was the sub-postmaster, rather than the operators of the system at any higher level. At the time at which that was written, October 1995, it couldn't have referred to Horizon.
I now appreciate that, yes.
It's right, I think, as you say in paragraph 208, to note that the Post Office was far from unique in its support for the repeal of Section 69.
No, that's absolutely right.
And I think since you've written this report, you have received a high number of additional submissions from consultees, which, say for one, supported the repeal of Section 69.
Yes.
I'm not going to examine any of those in detail because that may be a matter that we come back to later in the inquiry. That material has been obtained by the inquiry from the Law Commission itself.
Yes.
The one exception, was that a company that specialised in computer, the operation of computers and computer forensics?
Yes.
And can you just summarise to us what the opposition was, if you can remember?
So this was an organisation called Computer and System Telecommunications Limited, and their position was that computer evidence was always to be regarded as legally unreliable, and the question was only the extent to which it was unreliable, and that was apparently because of its, and this I quote without necessarily entirely understanding it, its inherent non-linearity, indeterminability and insecurity of the architecture of computer systems and software. And so the predicate of this submission was that it was necessary for there to be expert evidence to demonstrate that a computer system was reliable against a presumption that it would otherwise not be, because there was always the risk of faults within a computer system that anyone other than an expert might not be able to identify, and including the operators of a particular computer as being amongst those who wouldn't necessarily know that it wasn't operating properly in a material respect.
Thank you. In any event, despite that opposition, the Law Commission recommended repeal and repeal occurred?
Yes.
Thank you very much. So I think that's an appropriate moment to break for lunch if it is convenient to you. As you know, so we're aiming to finish by 3:15 today, and so if we broke now until 1:45, that would certainly give sufficient time to go through Mr. Atkinson's conclusions, which is the last and remaining topic for us.
Yeah, but that's fine, Mr. Beer. There's just one point that I'd like to clarify in my mind with Mr. Atkinson, arising out of the questions you asked him about what I'll call third-party disclosure. And I think I know what you're telling me, Mr. Atkinson, but if I put it in rather crude terms, it will help me to be certain about that. And it's this, really: if an investigator or a prosecutor gets to the point where they think it appropriate in order to comply with disclosure duties, that they seek disclosure from a third party, the fact that their contractual position with that third party might make disclosure expensive or difficult or whatever other word you might wish to use is irrelevant once they've determined that it's appropriate to seek disclosure.
Yes.
Is that correct?
And so they would, once they had determined it was something that needed to be done, then they needed to do it. And if they couldn't do it, they then needed to review whether the prosecution was viable without that having been done.
But the simple point for me to keep in my mind is that the duty to seek disclosure in those circumstances overrides any contractual position.
Yes.
And if they don't like the effect of the contractual position, they have to review whether or not to prosecute, and in an appropriate case, not prosecute.
Absolutely.
Fine. Thank you very much.
Thank you, sir.
Sorry, Mr. Eaten 2 minutes into your lunch break. If you want to make it 10 to 2, that's fine by me. Did you say 1:45?
I now say 1:50.
Yeah, fine. Thank you.